Proszę!
Zaczynamy, ale czyli tak, jest streaming, ale nie ma osób obcojęzycznych na widowni, tak? Ktoś
Na
wziął.
razie dwie osoby są, więc...
Okej, spoko, dobra.
Jak chcesz.
No to jedziemy, dobra. Hello, I hope you can hear me. This is seems to be key. Hi. Should I introduce myself or was I announced? Of course, presenting myself is not a big thing for me, so my name is Sara Dobrzańska. I'm a lawyer in Legal Culture Foundation, and during our today's meeting, I will have a pleasure to give you some general overview on the basic things related to copyright, which I hope will be useful for you, not only due to your future professional endeavors, taking into account the space that we're meeting in, you can relate to the wide artistic domain, but hopefully you will also be able to implement it in your personal relationship with the people of culture. Before we go to the gist of the topic, I would like to discuss a number of technical things. For the needs of our today's meeting, I have prepared a presentation that I would like to show with you, but this is a certain basis foundation for the discussion that we'll start today. So if there are any doubts or questions or comments on any of the topics that we will tackle today that you would think you would require more discussion or more explanation, you can always ask me. So you can ask questions during the presentation, and we also have a time for a Q&A session after today's presentation. There are no bad questions. There can be only bad answers. So I will try to solve all your doubts, and if this dimension of today's presentation will not be adequate to ask me questions, there's also a possibility of sending me an email with your question to prawnik@legalnakultura.pl. I will send it to you through chat. I think I can do it even now. So through this email you can formulate questions, which I will try to answer without undue delay. Are there any doubts related to that? If you have any questions now already, as I have technical limitations and the form that we're meeting in today on the online form, I do not see the room. So if there are any questions in the room, I would like to ask you. I would like to ask the organizers to listen to them so that I can answer them. You can write to me through chat. The form is any that you would like, and so after this lengthy introduction, let's move on to the presentation. Let's see if the technical problems will allow me to show you the presentation. Can you see the presentation? That's my question. Yes? Okay, great. As I mentioned, today our task is to bring closer to you the basic institutions of the copyright law. And if we have enough time, I would like to show you some data on some information on legal databases, among them the database available from our foundation, but more on that later. First, let's answer together the question, what is the copyright? In the literature, you can find loads of definitions of copyright, both subjective, objective, and of different mixed character. From our point of view, the important thing is what is protected by the copyright law and which results of human activity. I'm running a bit ahead of my presentation, are the subject of protection of copyright law based on the Act on Copyright Law of 1994. The topic of our discussion will be strictly understood the copyright law, but we have to understand that the Act on Copyright Law and the derivative laws does not protect only the authors, but also the people who are the performers of other people's works. but do it in an original way. And these are the derivative rights, which also apply to actors, to the roles they play, the musicians, instrumentalists, and also the rights of artists, performers who are singers and perform other people's songs. The copyright, to be more precise, is not only are the rights of the people who created the works, and the copyright also includes derivative works, which also protect people who not only created the work but also performed the work. And now I would like to move on to the next slide. I hope it will be possible. Yeah. Successful. The copyright regulates the rules related to widely understood human rights. It does not include the definition of the human right, but it defines the work, which is the key focus of this act. The work is any result of human activity which has two traits. One of them, it has individual character, and secondly, it has creative character, and it was defined in any sort of form. It doesn't matter from the point of view of copyright what is the value, what is the aim, what we want to use it for, the work that we have created. The important thing is that it should have two traits: the creative character, and was defined in any sort of way. The definition in the meaning of the law means that it allows other people to experience that work. So it has to be externalized. It doesn't have to written down on any sort of medium. It's important that somebody else apart from the author would be able to experience your work. So those three elements which will allow you to protect your work with copyright rights. With copyrights, is a picture a work? Basing on what I said, and also taking into account the content of the legal act, you would have to say yes, because photographic work is included in the in one of the articles of the work of the copyright law. Moreover, it is assumed that the majority of results has individual character, so undoubtedly it should be protected by the copyright. However, certain copies which do not have of work which are fixing of or definition of a work without creative characters, then it would not have the character of which have no creative character, which will not be considered, which will not be protected by copyright. As I said, the traits of works of art are the acts of human beings. This is based on the current. It's a key thing from the point of view of regulations right now, because even if the result of work, something is created through, for example, work of nature, which it will have original character. If it will not be created by a human being, it is not protected by copyright. Also, if, for example, an animal will include their creative input to some work, then such works will not be protected by copyright. The result of it is there is no need to have the possibility to use such a result of activity by other persons. There are also results of human activities which by the law were excluded from copyright protection, like protocols, official journals, national symbols. Even if they are creative character, there is a provision which says that these elements of human creativity, of human actions, are excluded from copyright, so we do not have to ask every time the author whether he agrees for us to use their work. I'm pointing your attention to that in the context of different national symbols, reports, and protocols, especially national symbols. They can be protected by other acts of law, which will require us as people who want to use that also for the commercial means, let's say the flag of Poland or the emblem of the national emblem, there are certain limitations to that. However, these limitations do not arise from the copyright law, and I don't identify any risks here. Another issue is that when you have the knowledge what is the under the protection of copyright, the issue related to what rights we have as authors, because we are able to create a work of art which is of individual and creative character. And now, a very important thing for the rights. Sorry for that. Which apply to authors. Coming back to our topic, the copyright and the results are automatically protected. We as authors, we do not have to go through any formalities. We do not have to submit our work to any national register. Do not have to pay anything for this to be protected. Contrary to the IP, for example, industrial property protection, the copyright is automatic, and if we have a work and it has all the traits included in the law, all other entities they're forced to secure our economic and personal rights, even, and we do not have to do anything to protect them. We need, of course, sometimes, if we, for example, sell some of the activities, we have to, of course, pay for some organizations to protect them, but we do not need to. The protection is automatic. Which rights we're subject to? The first times, or the first sort of rights, are the moral rights. The moral rights are directly linked to between the author and the work. And for example, one of the rights is that only the author is authorized to sign their work, unless he makes a decision to do it anonymously or under a pseudonym. But generally, this is a indelible right, and we, as people who are who are not the authors, we cannot make this decision for the author, and we cannot distribute this to other people, the other person's work, even if we have any sort of rights, including economic rights, about which later, and sign their work with our own name. Here, I have a practical request. I know that some of the authors prefer to distribute their work anonymously, but from the point of view of claiming your rights and identifying this entity to people who want to use our work, signing your work is not only a good practice, but also increases the effectiveness of the attempt to find the author, because there's very often a situation that when somebody wants to address the author and wants to ask to use their work, but identifying the author encounters insurmountable sometimes challenges. So if this is not against your sort of deliberate attempt, please sign or mark your work in such a way that other people would be able to identify you easily as the author. Of course, in the context of moral rights, the important thing is that they are not limited in time, which means that regardless of how long a time passed since the work was created, the moral right is always in force, and you are required to follow these rights, and these rights cannot be transferred to third parties. Of course, in practice or in economic relations, you can find contracts where the authors are required not to exercise these rights, but formally they are not transferable to a third party. Contrary to moral rights, which, as I said, contrary to the moral rights, we have this temporal independence. We have economic rights. The basic right of an author in terms of economic rights is the right to for the author to use their work and to dispose of it and to get remuneration for the use of it by third parties. These rights, as you can see on the slide, apply to the authors. They are limited in time. It's 70 years from the moment of the death of the author, and not 70 years of the death from the death from the moment of death of a recipient of the rights, if this was allowed to be used by other persons. But these are just nuances. It's good to remember that 70 years from the death of the author is the time which is required for the economic rights to expire. These economic rights, contrary to the moral rights, can be transferred with the through a legal action. Legally to a third party. They can be inherited. We can also grant them, donate them. We can transfer them, sell them, contrary to the moral rights. So after 70 years from the death of the author and the author of the economic rights, it enters the public domain. So a group of works with expired economic rights or which were created before the copyright was in force. It was difficult to identify me. I think I was, which was the last sentence, but after 70 years it enters the public domain, or the collection of works where the economic copyrights expired, it's not protected anymore, or by and also which includes the works where was not protected by copyright. So here I have in mind like very old works of art. Did you hear me? Yes. Can we move on? Do you have any questions or technical issues? Thank you. As I mentioned a moment ago, as a rule, economic rights are applicable to authors. There are certain exceptions to that. The first exception applies to works which are, I believe, in your interest, the audiovisual works, films, but also short forms. Because the copyright law has a certain legal fiction that if we're not possible that to prove that it's otherwise, we assume that the production is the producer of the copyright who has economic rights to all the audiovisual works, but also the whole of the audiovisual work which have been jointly exploited as a visual work. So if we're the author of a soundtrack for audiovisual work, then if we did not decide or we do not agree with the producer of the audiovisual work that it was introduced to, that was used, we are not able to prove that, it is assumed that the producer of the movie where this soundtrack will be published has economic rights to distribute this as a whole, including our soundtrack. And in such case, they don't need to ask us every time for the consent or get any sort of license contract through the fact through the fact of creation of this audiovisual work and the contract of using the existing works. They gain this right. The producer is also has the producer also can make a certain reworking or processing of works created, including translations into other languages, into other language versions. So it is required to get the consent of the owner of copyright just for the audiovisual work, not every single creator of every part. The second exception are the employee works. These are the works which were created within the frames of employees performing their job duties arising from their job contract. If you are employed on a full-time employment job contract, and if the work that we did is related to our work obligations, then once the work were accepted by our employer, then I'm talking only about the sphere of works which are created in a job. So if we create the work in our free time, let's say, then this will not apply in such case. However, the works that we create within the job relation, the moral rights are ours, but the economic rights are applied to our employer. So it does not have to be a general, like explicit consent to use that work of art or some sort of a declaration of a worker, of an employer. Just the fact that the employer will start to use our work can mean the acceptance of such work. The question which might in the current digital reality, not a key one, but it's good to remember that if your job description does not state otherwise, also the employer gets the property of a carrier where the material form or the other material form where our employee work was fixed. The provisions of the copyright law say that remember that it's only if the work if the employment contract does not state otherwise. So this is important to take into account when you are negotiating a job contract. So this also applies to the short-term contracts. Always pay your attention to if there are any provisions in the contract related to this, and if they are not good for you, you signal that very quickly and explicitly, and that you do not agree to that provision and to modify this provision. So that later that things related to the economic rights to your works did not bring any doubts or arise any protest from you. So let's say you created a work and the perspective of the financial perspective do not apply to you. So okay. Do you have any questions related to that part? If the topic will require this, I'll show you this change my perspective from the author to the perspective of the entity that would like to use. Okay. Is it okay now? Better? No problem. Let's move on to the issue of using other people's property, the property protected by moral copyright. If we want to use another person's work, So now I'm moving on to doing that from the perspective of of an entity that wants to use other's work, somebody else's work in our own work. The rule is very simple. Every time we should get a consent. Every time from the authorized entity, from the point of view of economic rights, it can be the author, or it can be an employer who then has the economic rights to an employee work. How can you get that consent, or how can it be granted from the point of view of the author? We assume that there are two basic forms of granting consent. The first one is making a license contract, signing a license contract in which we will state to which work an entity that wants to acquire this right can use our work. Please note that granting a consent does not have to be formalized in any way. It's just enough that we can able to prove that. But from the point of view of the easiness of proof, I would encourage you, if you have a need to use anybody else's creative work, you better get that consent in a written form and be as precise as possible for how much we can use the work, how we can use it, and which work we can use. So this will allow us to exclude some challenges so that the use of our because if we agree something verbally, it will be difficult to prove it if something goes wrong. So the first sort of a contract is a licensing agreement. Is that it doesn't have to be formalized. In case this is the sole license, so we exclusive license, we allow only one entity to use our work. This is then the required form is required. However, the license can be also granted in the email form. Granting somebody else's a license does not remove our economic rights, but it's a consent for other person to use the rights that apply to us. It's good to define this contract to what extent we and which fields of exploitation we're granting the consent, so, which means to what extent the other person who's can in which domains another person can use our rights, because that would also allow us to control what's happening to our work. The licensing is paid as a rule. If it's not paid, it has to be stated in the contract. It is also limited with time, so the time limitation should also be a part of a licensing agreement. Another form of a contract is a contract basing on which we're transferring legal rights to somebody else. For our perspective of the authors, transferring or shifting the contract to somebody else, we get so if we sign this sort of agreement, which formally has to be done in writing, in these fields of exploitation, we will not be able to exercise our economic rights, and the economic rights will belong to those who bought the economic rights from us. So, contrary to licensing agreement, this is not just a consent. This is a transfer from. It's a transfer of our economic rights to a third party. So, if in the future you will be securing such a contract, please note a very important from the point of view of authors the difference between transfer of copyright and granting a license. And on selected fields of exploitation, from the perspective of effectiveness and durability of such decisions, looking at it from a perspective of the author, the granting of a license is the better solution. However, it sometimes also makes sense to transfer the economic rights, but then you have to remember that you will not get any future profit from the work, even though that we will be the authors. It will be our works will not be belong to ours.
majątkowych z perspektywy czy udzielenia cen, fakt, że jest przeze mnie grupa utworów, których te autorskie prawa mają prawo, nie powstaną w Chinach, tych utworów praw amerykańskich, tak? Jakby ja cały czas jestem w tym samym miejscu i ruszam się nie dokonuję żadnych. Mam taki powód, więc wydaje mi się, że to nie wiem, co mogłabym zrobić, mogę
I don't know what I could do. I
ale
can repeat what I've said, but
okej.
okay.
To jakby przerywało, to proszę o sygnał.
So please let me know if the connection breaks.
Nie odczuwam.
I don't feel that in any way, so it's difficult to intervene.
Jak powiedziałem, wspomniałam są w domenie publicznej i na korzystanie z nich nie musimy mieć zezwolenia.
Okay, if things are in the public domain and we do not need any consent to use them. When it comes to things related to works that are available on the internet, please, I would like to point your attention. Hopefully that everything works well already. That 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 the works which are available on the internet are not the works which are excluded from copyright. It's the rules are exactly the same. We, as the people who want to use other people's works, when if it is analog sort of a work, if we use it for commercial, if we want to, if all the photography that you will find on the internet, there is the rule of protecting the copyright is the same. So if we say that the slogan that on the internet everything belongs to someone is still current, it's still valid. So
czy jest nam udzielona, na jakich polach, celów komercyjnych czy niekomercyjnych, bo to z perspektywy późniejszego naszego.
from the perspective of our further use of such a work of art is key to protect our rights and protecting ourselves from the claim that we use somebody else's work. We have to work. If we paid for something and we worked in goodwill, everything should be was according to the rule. In practice, it doesn't happen always. So it should be verified as well as possible, just to protect yourself from future claims. I was talking that the general rule of copyright is that we should get about few of those institutions I wanted to tell you, but the general rule is that allowed use. These institutions allow you to use the word without asking the author every time. However, not all the allowed use institutions are related to the fact that we want to use them without any sort of consent. This part, which is most used in our private life, the way of use is the allowed personal use, which is included also in the Copyright Act, and this allows us to use other person's works which were published by the author or entitled person for our own use. It's something that we can use free of charge. We do not need to pay anything for that. We can use these works personally, or we can use these works with a group of people that were in a uh, mm, close personal relation. These relations that are fixed and are not incidental, and there's something more that we just need to watch a film together. Is enough so that we can address it and we can use this use for ourselves. Please remember that within the allowed personal use, we can we can use the works that have been published, but we cannot disseminate them. So be careful. Here on this slide, you can see the basic, I would say, maybe a bit archaic uh, cases of or examples of using the personal use, allowed personal use.
turystyki na YouTube zwracały uwagę, proces muzyczny jest również fajnie można korzystać z znanego utworu muzycznego, żeby wzbogać nasz utwór. Takie sytuacje
Such
oczywiście
situations, of course,
dyskretuje
um,
bardzo często algorytm.
are quite
Algorytm
often
na YouTube jedna
found by the algorithm. Of course, YouTube does not know the copyright law, so all these.
Państwa twórczości, to proszę traktować poważnie, ale
Please treat seriously all the warnings that you get in relation to copyright law, but the issues related to the copyright law in its other uses that I will be talking about,
one nie są znane
they are not
algorytmowi, i
known to the algorithm
będą podlegać pewnej
and
kontroli również
should
służb
be also ideally controlled by a person who has the copyright. It's not always so. So don't be afraid. Try to explain the situation, understand it. If you have a reason to refer to the institution of allowed use, because it has to be argumented and explained. The second kind of allowed use that I will not delve too long on is the didactic, is the educational allowed use. So if you want to use another person's work within the educational institution, it's important that this work is used in case of scientific work or educational work in the school or in the university would be related to fulfilling the educational aim of the institution. We can use the works for didactic reasons, and this applies only to educational institutions. Even if we fulfill the economic institution, I mean, we cannot. I mean, even if our goals are lofty and if we do something non-commercial, etc., it does not exclude us from getting the consent from the author if this is not an educational goal. So in such situations, you should contact the author, and by describing the situation that you are in, the scope to which we want to use their work, ask on what conditions we could do that. Quite often in practice, we have answers of authors who consent that, but we need to get that consent before we use the work, before we use it, and not after it has been used. The allowed use, educational allowed use, is related to the works which are used for educational reasons. It should be based on the educational program of an institution. There are issues like, for example, movie nights in a school. The question is whether it's educational or more recreational. If it's recreational, then I would say that you should get a consent. I would say that the school cannot use it under educational allowed use. Within the context of educational use, when you use other sources of culture, if you're using books for scientific reasons, or if these books have like legal reservations that I really encourage you to follow the law, the rule of law, but we should know also to what extent we, as the people who want to use them, should do it according to the law. And there is and no reservation within the book or in the audiovisual work cannot make us lose the rights that are given to us by the copyright law. Okay, the law of quotation. This is another institution which causes a lot of problems in terms of interpretation. We quite often we're just quoting, but the question is whether is our intuitive understanding of this right, is it based on the copyright law? So please note that only in the case where if our understanding of the quotation law of quotation is covered by the copyright law provisions, then it will be valid.
Nasz sposób rozumienia będzie spójny, to wtedy możemy skutecznie
Then and only then we can apply this
Względu do tego
practically.
ustawy o prawie autorskim i prawach pokrewnych pozwala
The
nam
copyright law
uzyskanie
allows us to use
cudzych
other
utworów,
people's works,
drobnych
which have
utworów bądź fragmentów
a small works
utworów.
or parts of other people's works, only in case when
Utwór jest
this
wykorzystywany w
work is
ramach
used
naszego
within the
utworu.
frames of
Jednakże
our
nie
work.
możemy
So we're creating our own work, which has certain elements, and then we incorporate a certain a part of the work or the work itself. This is the basis.
w każdym zakresie
Not in every aspect, not in every way of work. We can refer to the law of for the rule of quotation. First of all, it has to be a work in the meaning of the Copyright Act. Also, we cannot use it just for any reason. We should remember that the Copyright Act foresees a certain list of goals to which you can use other people's work, and you have to be able to explain. I mean, it's explanation, polemics, scientific reasons, and the and the rules of the genre of activity. Only then you can use the quotation, and also by using this institution, you always have to name the author and the source. The quotation in the has to be discernible. For the recipient of the work, it should not be a problem to interpret which fragment is borrowed from another person's work and which is authored by us. The law does not take into account the percentage number, the percentage to which we should link our other person's work to our work, but so there's no set proportion. But this fragment, which we're using based on this institution, has to have the auxiliary character, so it should support our own work. It is not that should supplant our creative work or be parallel to something that has been already done. It should be used only for those specific goals. So if there are no allowed length of the quotation, we should remember about the function it fulfills. I also point your attention to the fact that the copyright protects works and not ideas that are included in other person's works. I would like to also point your attention to another group of works, which is called the inspired works. So, which were created as the reflection of our experience as a result of our experience of dealing with other person's work. I hope you understand that. However, it is inspired by somebody else's work, but we do not include in our work the original work that we're inspired by. So then we have no obligations arising from the Copyright Act. We can distribute such work, we can use it, we can use all the rights, and both moral and economic, without the need to get or to inform the author of the original work, which was our inspiration, that this is our attempt and that such work was created. Contrary to derivative works, in such a situation, the act does not put upon us um, the any obligations. But if you wanted to make a derivative work, so it's like adaptation of a script base of a work, literary work as a script, or translation, before, then we have to remember that before we distribute it, before we start to disseminate it, it should be,
ale także powinniśmy wcześniej uzyskać
we
zgodę
should
na uprzednie
get
tego
the
utworu
right to
od
disseminate from the
twórcy
author
autorskiego.
of the original work.
Różnica pomiędzy utworem zależnym a inspirowanym w praktyce często jest płynna. Oczywiście analiza konkretnego przypadku...
The analysis of course, this is quite a fluid thing, and we have to analyze every case individually, whether it's more of a derivative work or more of an inspired work. However, the criterion which you can use in practice in order to assess whether our work is derivative or is the effect of inspiration of work is whether we include in our work some elements which are creative and are borrowed in a way from the original work. If so, if our work come from if you use a similar context to other people's works, similar protagonists, similar soundtrack, and this similarity is quite material, then we should better treat that as a derivative work. If you want to, and in order to disseminate it, we would need to get a consent from the original author or the owner of the economic rights. Now that we have like this knowledge on within the scope, what is the subject of the copyright, which rights apply to the authors, we can, and how we can get consent or give consent to how somebody else might use our work. So 2 works about plagiarisms or any forms of illegal use by third parties of our works. I would like to point your attention that in case when some other entity is using our work illegally, we have certain rights.
Naruszył nasze autorskie prawa. Natomiast w niektórych przypadkach przywłaszczenie cudzego utworu lub wprowadzenie w błąd tego, kto jest autorem dzieła, może również wydłużyć odpowiedzialność karną.
If you use a work without checking who's the owner of the copyrights, you can get this is penal, can be subject to penal liability, and in such case, so if our or other person's behavior is forbidden, which is included in the Copyright Act, or is can be defined as one of the common crimes, or you are threatened by not only civil but also penal liability, criminal liability.
Zasadniczo to nie jest tak, że utwory dostępne na warunkach licencji Creative Commons są jakieś utwory, z których możemy korzystać dowolnie.
Of course, these are not the things we can use. Creative Commons cannot be used freely. These are also licenses which are defined by pictograms with which the authors use to mark their works. You have 4 types of here. These are the most common pictograms and types of licenses of under Creative Commons license. the important thing is that every time we need to remember that in which scope we can use the work of art, taking into account the conditions, so terms of conditions of a license, because these TNC are different depending on in every case. I mean, for every license.
Okej. W kontekście Was,
In the context of
zasobów
databases and the ways in which you can use, if you wanted, if you needed, within the frames of your own work, if you had a need to use somebody else's ready work, apart from the works which are under Creative Commons, I also encourage you, but maybe not at the moment, but to visit the sources of legal sources run by our foundation. It's being verified right now, whether the sources to which we want to encourage you and invite you are valid, current, and up to date. So this is a pre-premiere show presentation of this database, but I think in the nearest possible time it will be available on our website. And then we were through a web browser quite easily being sure that if we follow the license under which these works are published, we will be using these works in a legal manner. So I would encourage you to do that. In this presentation, I also included. Here I'm also including the links of the links to widely available databases which are legal too. And the question that I also would like to point your attention to, which is to some extent is regulated by the copyright law, but evades the regulation of one domain of law, is the protection of the image protection. Because I know that in practice, this question also raises certain doubts. I would like us to have this perspective that in order to preserve somebody else's image, we do not need to have any sort of consent. So if we wanted to use that image, the rule is that we need to get a consent. This is decided not only by the Article 71 of the copyright law, but it's also one of the personal goods, personal rights. So publishing other person's image without consent can bring a number of challenges to us. So or problems to us. So if we know that if we publish somebody else's image and this person is not an actor with whom we do not have a contract which allows us to publish their image, you should point your attention to that. The rule is for us to get the consent. Of course, there are certain cases where this is not necessary, but these are exceptions. The exceptions cover the images of publicly known persons, and only if this image was fixed or was acquired in relation to their professional life. So for example, an actor during a film premiere, but not actor when he's on holiday.
Prawo też nie przewiduje, czy to musi być 3 czy 7 czy 11. Ważne jest, żeby
if there are several people on the picture, it has to be a group picture. It has to be non-key for the artistic element of the image. So if we supplemented the image of a person A with the image of person B, it would not be of importance for our work of art. And then you do not need to have a consent of all the people included in the picture. The third cases are posed pictures. So if somebody is a model and poses a picture and gets remuneration for that, then getting this consent from them would not be necessary. But the basic rule is that we get a consent for publishing somebody else's image. Okay, so that's all from me in terms of presentation, but I hope that this short presentation of the copyright is for you, I mean, a basis for some questions. So I will turn off my presentation to, I don't know if I will be able to see you, but Okay.
Myślę, że kontakt bardzo powoduje, że będziemy się słyszeć.
Okay, we'll be able
Nie.
to hear one another.
Halo, halo?
Hello, can you hear me?
Nie ma pytań.
There are no questions.
Mogę to w taki sposób rozumieć,
Well, I can understand it in many different ways, but
się pojawiły.
if there are any questions,
Chodź. Zainspirowałam.
I did inspire. Yes?
Tak, słucham.
Yeah?
Halo, halo, czy mnie ktoś słyszy?
Hello, can you hear me?
Nie.
I can't.
Ja mam takie pytanie, bo ja samemu jako uczestnik...
I myself.
A teraz mnie może słychać?
Can you hear me now? No.
Halo, halo?
Halo, halo? Czy się pana słyszy,
A to
ale
dzień, dzień dobry. Ja jestem tutaj...
Dzień dobry.
Mam taką specyficzną sytuację, ponieważ w latach 70...
I have a very specific situation because I'm not.
ale ja pana nie słyszę. A mógłby pan mi to napisać w kartce? Chyba, że pan podejdzie do tego, bo pana Krzysztofa słyszę bardzo dobrze. Dziękuję.
Halo, halo, a teraz?
Hello, can you hear me now? Yeah, now I can hear you. Hi. I have a specific question, I would say paralegal, not related to copyright law, because apart from being a filmmaker, I'm also studying law, and I wanted to work with copyright, with the contracts, the things that you mentioned. But I encountered the problem of exercising being the legal counsel, the advocate. There is the limitation of working only in this activity. Is it so really? Is it so that I would need to decide one or the other? In the public space, I'm an advocate, so I'm a solicitor. I would not love to sort of get into my work. It's the same line of work, really. In the public space, we can observe people who combine artistic activity with performing legal counsel work, and it's an issue of certain ethical codes which apply to us as solicitors or legal counsels. If our operation, other than the legal operation, could not be sort of should harm our reputation as lawyers, then we shouldn't do it. But I've never encountered such challenges, and you can combine these two spheres, the artistic domain and the legal domain. You can combine it. I do not encourage you to resign from your fields of interest. And if you decided, for example, to get on the solicitor's application, the bar application, or the legal counsel application, it was so that you had the agreement of the dean that if you wanted to undertake other activity from your patron within the application, but I think such a consent when it comes to your activity, if your activity is not controversial from the point of view of reputation of your or professional standards or best practices it's usually granted. So if you do not things which are highly controversial, there should be no problem. No. I think at this stage, the rules concerning the code of ethics and the obligations and the possibility of combining our professions with other spheres of professional activity, they are changing. So there's a high chance that if you will be faced with that choice, please verify this and now be creative in both fields. Thank you. I think these are all questions. Thank you very much. Thank you very much. If there are any questions in the future, please send me an email. Thank you. All the successes. Thank you and goodbye.